Are you sure? Good evening, everyone. I'd like to call the Town of Cedar Lake Unsafe Building Department meeting for May 21st to order at 5:34. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Can I get a roll call, please, Cheryl?
Mr. Wojcik?
Here.
Mr. Hundley?
Here.
Mr. Keel?
Here.
Mr. Deutmeyer?
Here.
Mr. Ashton?
Here.
Mr. Conley?
Here.
Mr. Gatto is absent. Ms. Titus is present.
Thank you. Cheryl, you know what, I forgot, I see we have the minutes, but we didn't have the voting thing for approval of the minutes. Were we just gonna do that next month, or there was an
On the agenda?
Yes.
I did add it. Did I add it?
Oh,
It's on mine.
sorry, wrong copy, wrong copy. On my copy, I didn't see it.
Yeah.
Okay, moving on to minutes, January 15th, 2025 meeting, and February 19th meeting minutes, and March 19th, 2025 meeting minutes, as well as April 16th meeting minutes. Do we have any questions?
Nope.
If not- motion? Yep.
I'll make a motion that we, accept the meeting of the minutes as read.
Can I get a second?
I wasn't at that meeting, so I can't.
Oh, sorry, my bad.
You can still second, you can still.
If it's an acceptance, you can second. It's not an approval, it's an acceptance.
Okay. We have a motion by Mr. Wojcik, seconded by Mr. Huntley, to approve the meeting minutes. Can I get a roll call, please?
Mr. Wojcik?
Yes.
Mr. Hundley?
Yes.
Mr. Keel?
Yes, motion carries 3-0. Thanks for that explanation, Ryan.
Yep.
Moving on to active unsafe, item number 1, 9320 West 142nd Avenue, Northwest Indiana, Casas. I spoke with Tony briefly this afternoon. Junior Martin did reach out in an email, had some questions. The house is down.
Oh, it is
of course.
down.
Yeah, the house is down. There's still parts of the foundation there, I believe. So I'm gonna read the email real quick. This was in response to Cheryl's email, if he was gonna be in attendance at the meeting tonight. He said, unfortunately, I am not. Please feel free to update me here, and I will do the same. Update, I have followed up with utility, has not heard back from them, and do not believe that they have been out there since. I called last month. The team should be there in the coming week to seed, and I also mentioned to them that there is some cleanup along the foundation that still needs to be done. The property has been mowed twice and is on a regular schedule. Question, I spoke to the building department regarding future plans. I am weighing the possibilities of purchasing a new manufactured home to put there. Girl I spoke to was unsure about the answer, but I am not sure she understood my question. I have the setbacks and requirements from the website. However, being R1, when I look at the website, it looks like manufactured can be platted as a residential, or manufactured can be platted as a residential except R1. Is this correct, and can you provide more information on this? So when I spoke with Tim Kubiak also and Tony, they were under the understanding that that's an R2 zoning, and R2 manufactured homes are allowed. So what we'll do is reach back out to Mr. Martin for, with that answer and stuff like that. With discussion with Tony, basically, I feel that we're just gonna leave this currently where it's at. On active, I mean, we could move it down to update item, so that the house is down.
Or under permit,
Yeah, so what are you guys thinking? Because the demo permit is done, it's in the building department's hands right now, technically.
I would say we move it.
Remove it?
I think so. I mean, they did what we were looking for them to do, is take it down.
Yeah, I think mine and Tony's conversation today, though, is since the since the demo permit is not closed out because of seeding and stuff like that, that was the reason to not technically remove it.
Okay.
Rich, if memory serves me, was this one that he wanted to keep the foundation on?
Yes.
Has he secured the foundation so no trespassers could inadvertently fall into it or anything like that?
Yeah, it wasn't like it was a basement. So it was just the cinder blocks basically for the
Okay.
most part. So yes, it's, you know, he's gonna have to do something with it anyway if he puts a manufactured home on it, because it would not be able to go on that, you know, so-called foundation it was on. So I really don't wanna remove it from the list.
I'm just wondering if there's any part of the property that's still unsafe, like, you know, we had an issue, it might have predated you, where there was just a foundation left and we required them to, you know, they ultimately filled it in, but it was, you know, cordoned off, they put fencing and stuff up around it. I don't know if that was the same issue that they had going on here, that he still had to fence it in or something to ensure.
Yeah, it didn't seem that extensive by the way Tony was explaining it to me. You know, so,
I mean, otherwise, if it's a closing of the demo permit, we had this one on the turkey vulture house.
Yeah.
Right, in which it was kind of the seating issue, and then it was kicked down because it was, you know, they had to get the seating or whatever done. We moved it down to an update. You know, I would suggest that if there is no part of the property that's continuing to be unsafe, that it probably not remain on the active list, because I'm not sure that there's much jurisdiction that this board would have over it.
right. So do you think we would need to update until it is
Yeah,
finally closed on the demo permit?
what's been done in the past is it would become an update item. We'd ask Tony or whomever for monthly or, you know, bi-monthly updates as to what happens. Once that permit is closed out because it's been seeded or whatever remains, then it's removed off the list entirely.
Yeah. Yeah, so in other words, it'll stay on the list, but just move it down to update.
That's where I was
Where-
thinking too, yeah. Now, the other thing is, I thought I'm gonna drive, I wanna see what that foundation looks like.
Yeah.
Because we had one guy had the fence up on Lake Shore.
Yes.
If this needs a fence, we have to,
I looked from the road today, I drove past
Good with
it, but I didn't enter the property to see what's on the other, you
Yeah.
know, so.
that's the thing, I wanna see how deep it is.
Yeah, and that's the thing, I'm not gonna walk on there, that's, Tony wasn't, you know,
Yeah, he's gotta do it.
so that's, I would say leaving it on, update for sure.
Yeah, and then let's hear from him on it, and we'll go from there.
Yeah, and he's got no problem with communication with us,
Yeah,
so.
if he says it needs a fence, fine, if it doesn't.
Yeah, and I believe Tony would've told me that today,
Okay.
if it was.
I'm all about it. Good.
So I guess we'd be looking for a motion to just move this item to update?
I'd make a motion, we take us off active unsafe and move it to update item.
And I'll second that.
All right, we have a motion to move this to update item and take it off of active by Mr. Huntley, seconded by Mr. Hojek. Can I get a roll call, please?
Mr. Wojek?
Yes.
Mr. Hunley?
Yes.
Mr. Taylor?
Yes, motion carries 3-0. Item number 2, 12611 Klein Avenue, Kubiak Properties. Mr. Kubiak will not be here today. I did have discussion with Tim. They are getting closer. By next month, they should have the cameras up there, over on the building. This is the Salinas property, Jim. And so he plans on hoping to have that closed out and also the Fulton one at the same time. So, this one, we'll just leave this on, so if we have a motion to just defer this for another 30 days?
Yeah, did we do a 60-day on last month, or was it just 30 days? Because we knew what was going on with that, that it was taking time for all of that stuff.
Yeah, and I thought we did 60, you know, because of the timing with NIPSCO getting out there and stuff like that, but Tim told me that they're almost ready for it.
Give them another
It should be
30 or?
Yeah, so I say just do 30 instead of no needing to push it out.
Yeah, I'll make a motion that we extend the property at 12611 Klein for additional 30 days.
I second that. I got one question. They took the fence down, or were they in the process of taking the fence down?
Yes, because the fence was unsightly, and so they're keeping it locked, or the gate there, just so people don't go in. There was an issue with somebody that drove around it. So Tim was, trying to figure out how he would try to avoid somebody driving around just the front entrance. The fence had to come down, it was completely unsightly. And I think it looks a lot better with that. They're keeping it mowed with the bush hog when it needs it and stuff. can be mowed a lot easier now with that fence being gone. But yeah, I think, 30 day, so, no other discussion on it?
No, I think.
Okay, we have a motion by Mr. Hojek, to defer for 30 days, seconded by Mr. Huntley. Can I get a roll call?
Mr. Wojak?
Yes.
Mr. Hunley?
Yes.
Mr. Teal?
Yes, motion carries 3-0. Item number 3, 14714 Dewey Street, Michael Smith, formerly Urban James Linden. I didn't talk to Tony about this one too much yet. I didn't know if you had any update on it, Cheryl?
No.
I know that, I thought I saw Mr. Linden. He left? Yeah. Yeah, I saw him walk in earlier and then he was gone. So,
He sold this, didn't he?
he did.
Yeah.
He did sell, last I knew, previous owner had 60 days to remove all the items out of it. I drove past the house, and of course, it's still standing. Their intention is to demo it and build a new house there. I say that we'll,
Just leave.
yeah, but kinda with Tony not being here today with a better explanation on it, stuff like that, and Tony has been in contact with the new owner now. I think that we just probably defer this. I don't know what your thoughts are.
I say we just defer for another 30, just see where we're at with it.
Yeah.
And once Tony gets here, he'll have more.
Yeah, I mean, we were kind of on a timeline thing with the new owner. I really feel that they're gonna get something done with this. But nevertheless, it needs to stay inactive because it is still in the state that it's in.
When was it sold?
Last month?
2 months?
2 months ago?
2 months ago? Ryan, does that
And
ring
I'm
a
trying
bell?
to pull it up right now to see. Because the GIS shows it is now titled in the name of Fresh Start Interiors and Home Improvements.
Yeah, it is a business, but I have a contact name of Michael Smith.
I got a paper here too, it said closing date was 3/19.
Yeah, so it'd be the 60 days.
Yeah, the property card from the assessor is not updated, so the transfer obviously was pretty recent, which I think we all know.
Yeah. Do you feel, Ryan, that 30 would be sufficient for all of that stuff to get transferred over to where we can issue that, hey, you need to come in and fill us in on what's going on?
Oh, here it is. So, yeah, 3/20 of 2025 shows the date of the recording of the quitclaim deed to Fresh Start. So you said he had 60 days to get his stuff out?
From what I understand, that was verbal. I never seen anything written on it.
That would take us until roughly Sunday of this week. So yeah, I think that you'd want to get the new owners in, assuming it was 60 days. By June, Mr. Linden should have his stuff out, and the new owner should have a plan as to what they intend to do with it, so.
Yes.
I would think that bringing them in next month is probably appropriate.
Okay.
All right.
I would like to make it 60 days because, the other guy had plenty of time to do anything. Now we're making this guy rush to do it in 60 days. Just bought the house, he's.
Well, I definitely see your point on that, Jim, because if this company's gonna come in and tear it down, they're gonna need to come into the building department, present all their plans and stuff, and it could be premature with us seeing them again. So I kinda definitely understand 60, which gives them adequate due diligence to get their stuff to the building department, because then in 60 days, instead of us pushing it another 30 after that, if they get sufficient plans, what's going on, setbacks, everything, in 2 months, we could be saying, okay, thumbs up, it's in the building department's hands, we can remove it.
I agree.
Might I suggest one thing? I think the purpose of having the new owner appear in June would not be to make sure it's down by then, but to bring that individual before the board to explain to you guys what they intend to intend to do. I don't believe that's happened yet. I know Mr. Linden, as I recall, was the last meeting. I don't remember if the new owner was or wasn't. But
No.
I think that individual should explain to the board what their plans are. It's not that it has to be done by June, but it's to show that individual that the board does have jurisdiction over this. And if you guys are satisfied with whatever those plans are, then you could consider a longer deferral at that point in time. But bringing them here, I think, is appropriate, considering Mr. Linden was here monthly for many, probably about a year now. We want to make sure that the new owner stays on top of it and gives the care that is required under the town's unsafe building ordinance.
Yeah, I think I was just understanding Jim's intentions on, it gives them the time for the due diligence, and then if proper permits were pulled, it could, I guess, alleviate some meeting time.
Sure.
You know, that was just my thought on Jim's suggestion.
The converse to that is, if they do nothing, then you've lost 30 days.
Yes, yes.
Then we're bringing them in
Can we do
July.
60 with a requirement that they come in the June meeting?
Well, no, because they'd be required to come into the meeting, so I understand
Yeah, I mean,
Ryan is
it's up to
saying.
you guys, just,
Does that make sense, Jim?
I'd still like to give him 60 days because he's gonna have to get plans and draw a plat and everything else, so.
Well, but I understand Ryan, his, you know, for the fact that we need to know as the unsafe board on timeline and everything like that, because if we do the 60, yes, we did lose another 30 days. If, not saying that they'd be dragging their feet, but if they're really not, kind of pressured into the severity of the situation.
I'll agree with that, I just don't wanna be given 30 days extension every month.
No, but then, like Ryan did say, we can get a better better understanding if they are really, set at getting this done, and, because sitting there the way it is, they're not making any money on it.
Right.
They come back in 30 days, and if they hit the ground running, they could almost have stuff ready by then.
We can give them
not-
extensions if they need it.
Yeah.
So once we need, like you said, we need to know what's going on.
Yeah.
Makes sense. And then we can just give them 60 days if they need it.
If they need it at all.
If they need it
maybe
at all,
could be
right,
ready.
they may have everything there.
Yeah.
Okay.
All right.
So looking for a motion for
Yeah, I'll make a motion, that the 14714, Dewey Street, we're gonna defer it for 30 days. And we're gonna request that the owners, attend the June meeting.
perfect. I was gonna add that, but you beat me to the punch.
Right, second.
All right, we have a motion by Mr. Hojek, seconded by Mr. Huntley. Can I get a roll call, please?
Mr. Wojak?
Yes.
Mr. Hunley?
Yes.
Mr. Teal?
Yes, motion carries 3-0. Moving on to 14616 Dewey Street, Frick. I understand that he has not come into the building department yet. He did instruct us the last time, or inform us the last time that he was gonna come in and,
He was waiting for one thing, he said.
yeah. Nobody's had any contact with him. So if we can, maybe ask him what's going on. I don't want this to just get swept under the rug again, because it almost seems like it's gonna. I mean, I thought we were gonna be making some progress with the attitude that, he was having moving forward, and it doesn't seem like, we're gonna be back at square one, hopefully not.
A lot of the stuff on the exterior could be removed very easily. The trailers, the pontoons.
Some of that may be going.
Some of this is not current, Jim.
Yeah.
So just so you know, there was an email floating around. If you look at some of the pictures, where it shows the opening in the crawl space, Mr. Frick did get all of that stuff secured.
He said he was waiting for one thing, he got that one thing, and he was
Yeah,
supposed to go right from here to the building department the next day.
and he did not.
No.
I'd like to see us request him to come to next month's meeting.
Yeah. I didn't think we were gonna see him, because I thought he would've had permits pulled.
Yep. Thought we could take this off, but I guess not.
Yeah.
All right, so, we'll do another defer. All right, I'll make a motion then, is that, you're good with that?
Yeah, does that sound about right there, Ryan? Your thoughts on that? Because obviously, I mean, I don't know what your impression is, but I thought we were gonna see some headway.
Well, I don't know that my impression matters, but.
I know,
But my notes and my recollection were he had the plans, because he did bring them in last time,
Mm-hmm.
and it sounded like he was ready to get going. but without progress being made, without a report being made, I think it's wholly appropriate to order him to appear and to...
And with
figure
no
out what's going
communication
on.
to any building department, myself,
Yeah, I
or-
mean, we had this issue previously on that particular property where there was a package waiting for him at the front desk that wasn't picked up, and then there was, apparently a dispute over who was going to deliver it, if he was gonna get it or it was gonna be mailed to him. So to make sure there's no miscommunications, I would think it's wholly appropriate to have him come to the June meeting and make sure everything is laid on the table and everyone knows exactly what the plan is.
So I would think that this letter though, or this communication to, Mr. Frick then would be, I guess since he didn't, comply with what his request was, that he was gonna go and do this, and here we're 30 days in again, and, hey, you need to come to the next meeting, we need an explanation what happened. Why weren't you here before,
I know he's not happy with us, but that's his problem, because he was all set to go and he didn't do anything.
Yeah. Okay.
All right, I'm gonna, make a motion at the 14616 Dewey Street, Frick. We're gonna defer it for 30 days with the understanding that we'll ask him to come before the board at the next meeting, which would be June 18th.
Can I get a second?
I second that.
Right, we have a motion and a second. Roll call, please.
Mr. Wojak?
Yes.
Mr. Hunley?
Yes.
Mr. Teal?
Yes, motion carries 3-0. Okay, we're moving on to potential unsafe, 9110 West 142nd Avenue. That house is down. This is the one that we issued the letter to. I believe McAllister Excavating, was out there. I just drove past that one on the way here. It appears that it is seeded, all smoothed out and everything. So, I believe I have a question for Ryan. Since this technically is not on active unsafe, do we need to make a motion to remove this?
I would say just for clarity in the record, I would.
Yeah,
Just make the motion, we can...
count it as it worked out.
Well, that was kind of the idea when the board had talked previously about sending letters to folks, was to try to get people to respond and to take affirmative action without the board kind of having to step in. So, on this instance, it worked out, and it saved the board a bunch of time. It probably won't always work that way, but obviously, you had the right circumstance where it did, so that's
Yeah.
certainly a win for you guys, I would
And
say.
it worked on the other one in Cedar Point Park as well with the garage, so.
Yep. Was this the same property?
This was the one that had the garage last year.
Yeah, and we sent them a letter, they lived down in Indianapolis.
Yeah, and they
or
moved
something.
since then, so.
And they took the garage down and now it's a house, right?
Yes.
So it's the same owners, we, I guess, probably figured that they were going to be relatively...
And they did comply like the last time.
Yeah, so, good?
Okay, so, be looking for a motion to just remove this off of the,
I'll make that motion, I'll remove 9110 West 142nd Avenue off the
agenda.
potential unsafe.
I'll second it.
All right, we have a motion to remove this from the agenda from Mr. Huntley, seconded by Mr. Hojek. Roll call, please.
Mr. Wojak?
Yes.
Mr. Hunley?
Yes.
Mr. Teal?
Yes, motion carries 3-0. Item number 2, 13857 Huseman Street. Tony did not have any update on this, on me, other than he doesn't believe anybody, spoke to the adjacent property owner. This old well house is kind of in a little square on its own, kind of within, this individual's like yard. So, I don't know if there was any communication. He said he hasn't. I didn't, speak with Tim about this one. I think this one's gonna need to stay on there until we get something resolved with this, because it definitely, someone can definitely enter through there. Do you see that, Jim, on there?
Yes, that's not an active,
It is not active. No, so it's not active, however, it is open. Can somebody go in there? Yeah.
And it is on private property, I remember, right? Or it's right on the border, right on the edge?
Yeah.
would that belong to the subdivision, or is there an owner for that?
Can you see on GIS?
GIS shows the owner as the John D. Collins and Terry L. Collins Living Trust.
Yeah.
And that's the adjacent around the little square.
We can't do anything until we talk to him, until Tony talks to him and says for something, or can we
Well,
letter to him, or?
I don't know that any of these have unsafe premises reports on them, so really, you can't even move them to active until that's actually happened.
right, and I think, like John just said, as far as a letter, when does this one just come out to, I know Tim, Kubiak and, Tony can go over and speak to Mr. Collins and mention it to them, but do you feel it would be better with a letter with a paper trail? I don't know what your guys' thoughts are.
Have they ever been informed that this is,
I don't believe Collins has been notified yet.
so, it might be worthwhile, because we sent a letter to 9110 West 142nd, right?
Yes.
It might be appropriate to send that same type of letter to Mr. Collins and Mrs. Collins and figure out if that's gonna get us anywhere.
Yeah.
Otherwise, the problem is, it's like, you guys talk about these theoretical issues, the property owner's never informed of the issue, so nothing's ever gonna happen.
Right.
Right, it's just like talked about.
Yeah.
He might take care of it right away.
Good.
Take
Or
the
they
letter
might thumb their nose at you
Take
and
care of
then you
it
know
right
that
away.
you gotta
Got the
do
letter
something else.
done.
Yeah.
I know that subdivision over there has their own water system, and I was wondering, this old pump house might be belong to the HOA or whatever it was back then, the association.
Yeah, and it's not anymore, it's Mr. Collins. So, I think we'll just, I'll discuss with Cheryl and Terry, as far as how this letter can be written for this one, and go from there, see if we, the last two letters that we issued, the 134th and the 142nd Avenue, we did a 60-day. Do you think it would be suiting to do the same on that, I think?
Yeah, I think if that's kind of the standard practice. And, to address one of the questions before, it looks like the subdivision, the Lakeshore Subdivision Association deeded it to the Collins Trust in 2022.
Mm-hmm. Okay, so I think there's no action other than just instruction to Cheryl and Terry to draft a letter for 60 days.
Correct.
Yeah. All right, and I'll work with you, Terry, and Cheryl on that sometime by the end of this week.
Okay.
13520 Hobart Street, potential unsafe. I did drive past this one today. I did get some information. I guess I'm gonna just cover these next 3, 4, 5, and 6. Right now, without putting some good eyes on it and have Tony here, I know we discussed in the past, prior to you being here, Jim, that when we were gonna start adding some of these, that we were gonna possibly sending out letters, we were gonna do a worst first. Tony did have a list. It was outdated a little bit, and that's why John has created a quick sheet to go and do a quick evaluation from the road, so we can issue a letter. With those, I think we can wait till next week. Those didn't seem as pressing as the one that you brought to our attention.
Hobart Street's, it's secure, no gas, it's just, a lot of buildings, and it's just.
They're keeping it maintained.
Right down the road, yeah.
Yeah, they are keeping it maintained. I did discuss them with Tony. His first thoughts were, there's been an ongoing issue with 8707 West 141st. That's the one that I seen the email from you, Jim. Big hole on the east side of the house.
East side,
The east side of the roof as well. Huge issue. I don't know if anybody's living there.
There was three cars in the driveway was there any there when you went by?
There were cars in the driveway, but I don't know if it's adjacent house or
Yeah,
what.
there too, there,
Yeah.
Yeah.
one driveway.
But it's-
driveway line, yeah.
The hole on the east side of the house, mid-house, is about the size of a garage
Oh,
door.
absolutely, you could see inside the whole house. Yeah.
I don't understand it, but nevertheless, I think we need to, issue this one a letter because there's been active complaints on it before. Communication with the property owner, nothing kinda gets done, so I'll get with Terry and Cheryl on this one to be a little more specific and, you know, as to all the issues with this one and, instruct them to send a letter out on that by the end of this week.
Chairman, this might be a good time to kind of discuss policies and procedures, I guess, for these moving forward.
Okay.
So, if kind of the initial step is going to be what you've done with 9110 West 142nd, send them a letter, see what happens, right? As we've established, great success there. Can't expect we're gonna bat 1,000. So, we probably need to consider and kind of figure out what the parameters are for the contingencies for those cases in which people don't respond and don't do anything. And by that I mean, in order for it to go from potential to active, as we discussed before, you need a unsafe premises report, which requires Tony to go out there and do it, or someone else. At what point in time do you want those reports completed, right? Do you want to wait the full 60 and see if they do something on the 59th day? Or do you consider, you know, nothing's happened, haven't heard from them for the first 30, do we have Tony go out there and do it? Otherwise, you know, you wait 60 days from now, so we kick it to the July meeting, come back in July, they haven't done anything, then you send Tony out there, so that moves us then into August.
Yeah.
And then it wouldn't be until August that the board could actually find it to be an unsafe property, which at that point in time, you would notify the property owner to come in, and then it's September, right? So we've lost time in there.
Yeah.
As opposed to, you give them till July, haven't heard anything in June, Tony goes out there, you know, they come in, you know, nothing's happened by July, Tony's already got the unsafe premises report, and you save yourself a month.
I think with this, you know, specific one, 8707 West 141st, knowing, you know, the history that kind of Tony caught me up on, I completely understand with that.
Going on for 3 years.
That we issued a letter, but instruct Tony to start the report, because we know we're gonna need to probably go there just because of what's history.
Yeah, and that's kind of a larger point, is not just for this one, but for all of them moving forward, is you want to sort of set parameters, like, you know, we come back, you know, we'll be back here in June, right? You're talking about it in June, and Cheryl or whomever reports, haven't heard a word from them, right? Letter's been sent, haven't heard anything, nobody's come in for a permit. At that point in time, you know, we're halfway into it. Do you guys want to give the direction to Tony then, like, hey, you know, we're halfway through, have the report for us the next meeting, just in case.
Yeah,
Worst case
I
scenario-
like that idea.
Worst case is Tony wasted a little bit of time prepping the report, but, you know, if that happens and they've taken action, then, you know, we got the intended result versus losing more time. I
Ryan,
guess
as far
is
as
the
the
question.
paper trail goes, because I went and saw it, Rich saw it, should we do that form that we created just to stay within that paper trail? That I went and saw it visually, did the preliminary report, passed it on to Tony, do we need that, or?
I mean, we need a unsafe, in order to declare it to be an unsafe property, we need the unsafe premises report.
So what I'll do then is I'll just do the report, pass it on to Tony, and he can keep it with his, when he does the official.
That's fine.
unsafe.
I mean, if you're making your own reports or your own notes or whatever, you can certainly give that to him for his use.
Okay.
Tony is the one that ultimately, unless they've given it to someone else, he's the one that prepares the unsafe premises reports, which are then, you know, would be included in the packet in July. You guys review it, say, yeah, it meets the criteria, move it to active, or it doesn't, or whatever.
Yeah. And I know with the 9110, there was an issue with them, they moved and we had to resend and stuff like that, delayed a little bit, but for the most part, that 134th came in fairly quickly from receiving it, and, you know, I think we'll know within the first 30 days, like you said, to where we take action as a board on midway through that 60-day notice on start the report.
And just for future reference, I know we've had in the past, there are properties that have come up in which owners have either all died or people have moved away and nobody's ever heard from them since.
Yeah.
Like, in that circumstance, and obviously it's a case-by-case basis, but something like that, you might want to consider the fact that sending a letter to those people might just be futile, and you just move straight into having reports done. There are going to be times that probably will come up, that, you know, you can sort of set what the ideal procedure is for most, but just know that there might be circumstances in which you deviate from that because, you know, the circumstances call for it.
Yeah, and two of the ones that were, 3, 4, 5, 6 on potential, two of them were out of state. You know, one was just in Illinois, Chicago Heights, one was in St. Augustine, Florida. You know, so we know how that long distance stuff works. So, I at least looked on those just to see what we were dealing with, if it was a company, if it was individual. The Holbrook Street one was under a lady's name and it was under a trust.
Yeah.
So who knows?
Yeah, I mean, I'm just suggesting that if we kind of have a pattern of practice that is followed, you know, for these, so the expectations are the same for all of them unless there's a unique circumstance that warrants something else.
Yeah, because like you said, not all of them are gonna work out how the letters have been so far.
Be great if they did.
Yeah, it sure would. Sure would, but yeah. All right, nothing else under potential unsafe. Moving on to under permit demo orders, items 1 and 2, the 7105, 7109, 128th. We do have some correspondence from a potential buyer. I believe they were wanting to close. They did have concern with the demo order on it. I did speak with Ryan so he can kind of be on the record for it's similar to the one just up the street that just sold. If you could explain, Ryan, about how that works with the demo, how it shows a lien, but it's a zero value.
So, since these orders were entered before Jim and John's involvement, I'll give you kind of the brief, the teeny tiny bit of background on both of them. Both were on the active unsafe list for long periods of time, Cagnina for years. And there was a lot of kind of back and forth as to whether it was going to happen. And ultimately, at least the Herrera property went up for sale and was purchased by Ms. Herrera, who then shortly thereafter immediately turned around and put it up for sale again. Due to some circumstances beyond her control, from what we know, that were not great in the neighborhood. Your predecessors had kind of taken the approach that for these properties that people were coming in and were kind of looking like, you know, had been on it for a while and were just like, we're going to sell it. The unsafe building law requires them to notify potential buyers that the property is on the unsafe building list, that it's the subject of the Unsafe Building Commission. We have had circumstances in which people have purchased properties that had no knowledge of it. I believe the first one on our agenda today probably falls in that category. It's prior owner, Ms. Pamela Broadway. I don't believe ever informed NWI Cassis as to what was going on, and that just set everything way back. So a lot of wasted meeting time trying to deal with her and then having to kind of go through everything else that had already been done with her. In order to kind of avoid that, what the unsafe building law does allow is once an order is entered, and the first time we've ever done it was last year with these two properties, the Unsafe Building Commission is allowed to record those orders. So for both of these properties, when the board was informed that they were going up for sale either again or for the first time after being before the board forever, what the board decided to do was to proceed with the demolition order being approved and entered into. Once that was done, they were going to record them, simply because once it gets into the chain of title, then it provides notice to potential future buyers that it is declared to be unsafe, it is the subject of this commission, and so to encourage them and at least give them knowledge that this is a process they're gonna have to deal with. What we ran into with Herrera is when Chicago Title ran their title search, they obviously saw the unsafe building order, and they were treating it in the same fashion as a lien, a sewer lien, an HOA lien, whatever. They were looking at it and calling us for payoffs. And what we're telling them is it's not that, right? The town didn't demo the property. And what we told, and I believe, Rich, you can correct me if I'm wrong, what you guys told Herrera and Cagnina was, you know, the reason to do it was to protect the town, that the town was not intending upon executing on those orders to give them time to sell it, unless and until, you know, we got to the 2-year mark and hadn't sold, stuff like that.
Yeah, and to protect any future buyer for knowledge of it being on the unsafe list.
100%.
Yeah.
So Chicago Title, we got into contact with them. I know there's some back and forth, but, you know, what we told them was there is no payoff, there's no number. This is just an order that required the demolition of the property. It's a public record, it was done pursuant to the unsafe building law. There's no payoff, there's no number, and the town isn't going to release it and couldn't release it until there was public meeting action, because it was an order that was entered into by the commission. So they are zero balance, they're not liens, they're actually like administrative orders requiring the property owner to take action. So I think Chicago Title, ultimately Herrera property closed, so they were satisfied with whatever we had sent them and talked to them about. And so was the buyer was obviously satisfied with that. But there was probably a little bit of confusion because I don't believe these are done terribly frequently. These were kind of two special circumstances that led the prior commission to record them. But there's only one left, it's Cagnina's, and as I understand it, there's a potential buyer out there, so.
Yeah.
Would this also apply if it was purchased on a tax sale?
Different, right, if it went up for a tax sale, when you purchase it at tax sale, all those other liens are gonna get wiped out, you know, off of that property. They'll still exist against, you know, the individuals. Would the tax sale buyer have notice of it? Absolutely. So, you know, if you know, John Doe bought it at tax sale, they couldn't, a year later, once they actually get it, come in and say, well, I didn't know, right? It's in their chain of title. They're required to give notice to anybody with a substantial interest in the property. Generally, the way they do that is they run title searches on them, and they would have picked up the order along with whatever else is out there. But, good question. Tax sales, Jim, frankly, are a giant pain in the rear for the board because you get stuck in a limbo period, all right, where someone buys a certificate that they don't have a ton of rights in until a year later. So then it's who are we dealing with, who can we talk to, what should happen or what could happen, should we go in and knock it down while this certificate is pending. The prior boards have wrestled with that issue in the past. Usually the buyers have been okay to deal with, generally, but the problem is the amount of time it takes. So it's generally not a great situation.
Thank you for that.
Good, yeah, thanks for that explanation, Ryan. Moving on to item 3, the 73-year-old, as Ryan did mention, this one did sell. I did speak to Tony about this today. The gentleman did come in to pull a permit for a remodel. Tony and the building department had some concerns on the low dollar value of this permit, so they asked for a better explanation, scope of work. They met with the individual at the property. Tony did mention about the house that was getting the new foundation on the north side of the lake, across from the Eagles. The gentleman then kind of stopped what he was doing and just up and left. Came back with individual from Don's Foundation and is getting a game plan together on the quote on lifting the house, putting a foundation under it, or just completely demoing it. So this is just gonna, you know, remain under, you know, building department's watch right now, stay on the list. I'm pretty hopeful that the gentleman is pretty ambitious with wanting to get this done quickly. So let's hope that the estimates are good either way. So he is making an improvement to it. That's the intention. So that one will stay where it's at. As I mentioned earlier with the Kubiak parcel, the Fulton Street house is down, it's not finished out yet. That will be finished by next month. Tim said he's got to get out there and mow. House is down. Of course, the weeds are growing up pretty quick right now. So we should be able to remove that one next month, providing it's seeded. The 1333 Lemoore Street, I do have communication from Tony. He shared with the property owner, currently L&M Builders now. This is the 4-unit on Lemoore Street. Tony shared, it says, Dave, please find the attached document which was sent to the owner, 1333 Lemoore Street, on 12/9/24. This list was expected to be shared with any potential buyers.
I thought the guy who was in here, he came in with a plan, he was all ready to go, we gave him the time and...
Well, I think they needed to see what the requirements were to maintain this as a 4-unit.
Oh,
You know,
okay.
separation between, units and stuff like that.
All the fire codes.
So I think right now that this will remain here because they're working through that. I have not seen any, response back to Tony's email to the gentleman at L&M Builders. But I think they're trying to work through, at one point, I have even had confirmation, or, communication with them on whether they would tear it down and just completely rebuild. However, there was some concerns on multi-unit in that area, even though it's been having 4 gas meters and 4 sewer, hookups since
4 electric meters.
1973.
Yep.
So,
Meters.
I say that'll just stay.
Is it gonna remain then a 4-unit, or are they gonna try and...
Well, that's what the intention was from what I understand. But they do have a permit. I didn't ask Tony on it any other than what they were gonna do. They were gonna put a new foundation under it, I
I
understand.
remember that, he said, yeah.
But, we can discuss more with Tony next time, so, you know, it'll stay there. He's been in communication with them pretty good, for the most part, so I don't see any
Yeah.
need to,
As long as he's on it.
yeah. 13947 Hobart Street, Griswold. Tony was out there today. I did drive past it after the last meeting, like a week after. The gentleman was actually out there with the tractor leveling some stuff off. Tony did say that it is leveled, and everything looked good to him. I believe he's got it listed for sale, is what Tony said. So, other than that, the house is gone, everything's leveled, so I think this is another one that we can take action to remove it from our list.
I agree.
So,
All right. All right, you want a motion on that one?
yes, please.
All right. All right, I'm gonna make a motion to remove the 13947 Hobart Street under Griswold.
All right.
I second it.
We have a motion and a second to remove this from the agenda. Motion made by Mr. Hojek, seconded by Mr. Huntley. Roll call, please.
Mr. Wojak?
Yes.
Mr. Huntley?
Yes.
Mr. Kim?
Yes, motion carries 3-0. Let's see, moving on to update items, I did not speak to Tony on Fouch. I know he's been keeping his eye on it. Same thing with Diamond Peak.
Diamond Peak, we need to,
Yes, I seen the message
Yeah.
about the door was open again.
it's literally off the hinges, and on the west side of the barn, you know, the lower windows are broke. I see the kids go in there all the time. I pick up my grandkids on the corner right there from
Yeah.
school, so
Is it still there today? Cause I seen
open.
one of their Diamond Peak trucks driving away from it.
Yeah, no, they
But
drive, yeah.
I didn't drive around.
They drive through every day over there because of that.
Okay, I wasn't
No,
sure if you
it's
were
still
actually
open.
there taking care of it, so I will actually reach out.
He might be here tonight, isn't he?
They're losing more and more.
Are they gonna be here tonight?
Do you think they'll be here for the planning?
Cheryl, do you
I don't think
know if Diamond Peak is here or
so. I
not?
don't think they are.
I was looking for a truck to grab them and just tell them to
No.
secure it, but.
They're not?
No.
Okay,
Okay.
yeah, I actually ran into, and I totally spaced it out, I ran into Mr. Herbert, Sunday,
Mhm.
picking up lunch, or breakfast, I mean, on Sunday morning, and, I totally, you know,
If I see him
that wasn't
tomorrow-
on my mind Sunday morning.
If I see him tomorrow, I'll just do a face-to-face with him and say, can you guys button this up real quick?
Yeah, just so we know it remains secure.
Yep.
Okay, 6599 Fernwood, Mogan, any more update on that one, Ryan?
No, that's the one that we demoed?
That's the one we demoed, that's the one with the estate,
No,
and,
we're still waiting on the estate to do something, so.
and do we, I don't remember the exact, information you gave me last time on timing on stuff like that. I know there wasn't much.
You know, as long as it takes them to liquidate the estate, I mean, that estate, if you remember, that one kinda drug on a little bit, so, who knows?
Yeah, I do know the other parcel though that was on the same time as this, they're making some good headway on
Yeah,
that
that one
one.
was the one that was purchased. so.
The one that was
Yeah.
purchased, yeah, I drove past there, on my way over to the Griswold one, and, they are moving right along with the remodel on that one. Okay, same thing with Ward, that's just gonna be
Yeah, so I'll go off on a little bit of a tangent again, just to bring John and Jim up to speed. So, the way this typically works for us, when we have an unsafe building order that the town actually goes in and knocks the property down. After that's done, typically what happens is the town puts together a bill of costs for all of its expenses, sends it to the property owner. We don't generally have a really high batting average in terms of collecting directly from the property owner immediately, although we did have a couple in the last couple of years that paid. Many times, especially Ward, was kind of the problem I alluded to before. Both property owners are deceased. Their last known address was in Florida. We don't know where they're at. So, in a circumstance like that, when you're not gonna collect on it, what we do is, under the unsafe building law, about, 7 or 8 years ago, I worked with the State Board of Accounts to get a form approved by them that we could file, essentially like a lien. But it's, under the law, it's kind of an abbreviated litigation. So we file our sworn statement of the lien. They have 30 days to respond. If they don't respond, we then move the court to enter judgment against them. We filed those both for Ward and for Land Bank Builders. In both circumstances, none of the defendants appeared. We filed motions for entry of judgment last month, which Judge Parent last week granted both of them. So as of now, there are active judgment liens against both of those properties. When and if they are conveyed, that lien will be satisfied. Those liens are good for 10 years. Now, the Ward one is kind of the unique one because I don't think the Wards are gonna sell it. Because I'm not even entirely sure there's heirs to the Ward estate around or are gonna do anything with it. So that's...
A year ago, I heard that there were, and that there was a communication issue between the two. I also heard that there was only one left. But,
Ultimately, it's
Yeah.
going to be the town's call as how they want to handle it. The risk goes to Jim's point earlier is nobody pays the taxes, it goes up for tax sale. All the work you guys have done goes by the wayside. Alternatively, what you can do is you can file a foreclosure action to foreclose on your lien to ultimately sell the property and go on. I have no idea if there are mortgages on these properties. I highly doubt it because given the fact that the Wards are deceased, I don't think they'd be paying their mortgage either. So, that one minimally I would assume without having the title commitment in front of me is free and clear. So if you were to foreclose on it, you'd name any other people that have an interest in the property, and then it's just like you're foreclosing on a mortgage, right? But that's the only way to get your money back at that point in time. Because I don't think they're selling. Land Bank, they should probably sell, but that was a unique circumstance in which they came in and they were all ready to move on it and then just completely fell off the map.
mhm.
So, maybe they're having liquidity problems, I have no idea.
Okay. And that was item 5 with Land Bank,
Correct.
7020, 139th. Item 6, 127th Lane. I understand we do have both of the appraisals for this. Dave, I guess this question would be when do we move forward with this, with these appraisals?
Shortly. I need to look at the title work, and I need to make sure we have the, all holders of interest, so we can proceed.
Okay. And I did receive, and I will forward it to your office, Dave, I did receive the information from, Tim today. He actually texted me, so I guess I could just tell you it. I asked him on the bill from, that he tore down the structure, he did present it, to, I believe, Monica and Jennifer, for the 127th. The total was $6,120 plus administrative fees. So I'm sure that will all be taken into consideration as well with the appraisals on that, or not, or does that just
It'll all be analyzed together.
analyze together? Okay, just so for the record, that's what the town's cost was for removing the building.
Correct.
All right, item number 7, 14324 Edison Street. This is another town-owned parcel, just north of 144th, east of the, creek there, I believe Cedar Creek it is. Tim explained to me at the end of last week that he will be tearing down the house over at the WPM site.
Okay.
Once the equipment is there, he's going to move it over, to this parcel to get that one torn down. This has been on the list also. It is extremely difficult to get to.
Isn't that the one where we wanted to put a pavilion or something up there?
So that was my thought.
Yeah, I thought it was a great.
Yeah, so, but the sooner this gets done, the sooner a plan like that can happen. I did mention it to Parks as well, but as it sits, it's
It's hard to.
kinda hard to do at this time. But nevertheless, Tim needs to get out there first and make a trail to get to the house. There is access off of Rockland, Sherman, it's labeled Sherman, somewhere else it's Edison, on a pre-platted road that I feel will never be. But nevertheless, Tim did tell me that as soon as he's done with the house over here, he will get it working on cutting a trail to tear this one down.
Yeah, he said it was gonna be a.
So the sooner it's there, it's off of our list, and,
He said it was gonna be a lot of work to get to it.
yeah, so, I guess, if we have nothing else for discussion, we can move to public comment?
Yeah, I've got nothing, I'm good.
All right, public comment for unsafe building.
Grosek, 14055 Deodore. I just have a quick question. Are fines ever issued to individuals who are in non-compliance in Cedar Lake? I've been coming to these meetings for quite a while now for Unsafe, and just to be honest with you, I think this board's being played. What I mean by that is the individual that owns the property at 14616 Dewey Street. The reason I say that is, he comes in here, acts like he doesn't know what's going on, walks out of here and he's laughing at this board. You said he was supposed to be here with, he was supposed to get a building permit the next day.
We've had
He hasn't
problems.
done anything.
Yes, sir.
The reason I ask about the fine, why don't you give him a letter in 2 weeks, say that you have to have your building permit in, or we'll start fining you. That'll get him to move. And that was my question. Do you fine people for being in non-compliance? And to me, he's in non-compliance.
I know we've had that discussion in the past, and, prior to me being on this board, I've thought of that as well on some of the individuals that have been on this list prior, go and remove some brush from around there while the sheds were still up, stuff like that, you know,
Sure, sure.
year, 2 years, not progress in my eyes, and I was always thinking if there was a $75 fee, fine, whatever, for a non-compliance like that, it would kinda light a fire to get some stuff done.
Get a kick in the rear, right?
But, as the current ordinance is, Ryan, how would that look for us to do that? I guess the main answer would be right off the bat is no,
Okay,
from this board.
Just, because we've never done it before, as long as I've been attending these meetings, the unsafe building law does allow it, if I can turn this page.
and that would be something that should be looked into, then.
The problem is, and it's more of a,
I'm done.
Thank you.
it's a policy question for you guys, is if you want to fine people, we have to take the steps to enter orders against them, because only the order, in non-compliance with the order, can be fined. Not, hey, they came in and, right, you're not a court, it's not like somebody tells a judge something that, you know, the court fines them or issues a contempt citation if they fail to appear. You don't have that same power. Your power stems from the statute, which allows you the ability to fine someone for not complying with an order. But that's the added step of, you know, somebody comes in and says, I'm gonna do X, Y, or Z, and the board reduces that into an order and then issues it, and then, you know, goes after them because they haven't complied with it within 60 days.
How does that work then with the actual zoning ordinance then?
Two separate items, right, if you're talking about zoning ordinance, and I think the question was about this board.
Yeah,
This board's authority to fine comes from the unsafe building law, which requires there to be an order that was not complied with. If you're talking about the zoning ordinance, you're talking about a town code violation, separate deal, that could be cited for whatever the town code violation is, that would end up in town court, and we would've handled it last night.
yeah.
Or in July.
Will the fines be in town court too? They would be just local ordinance violation,
Yeah,
right?
anything, so.
Wouldn't have to go to a municipal court for anything?
No, what I typically handle in town court is, you know, if you're talking speeders or stop signs,
Mhm.
but the overwhelming majority of our cases are town ordinance violations.
Okay.
Nuisance violations for tall grass and weeds, abandoned vehicles, dogs running at large. I had one of those last night. Like, those are kind of the things that mostly end up in court, not really a ton of speeders or stop sign runners.
How, I guess, would it be comparable to, like with plan commission, like being after this meeting, on, there's discussion in those meetings to where if this isn't moved before this and this timelining kind of stuff, there's, you know, talks of this much per day, that much per whatever. Is it similar to that?
Those things are probably found within whatever provisions of the zoning ordinance or subdivision control ordinance the plan commission's operating under. Here, like I said, your fine ability is within the statute, but we have to follow the statute, which requires there to be orders, and if they request a hearing on the order, we gotta have that hearing. It's another step that, it's up to you guys if that's kind of the path you wanna take.
But with the, you know, concern brought up, you know, by Mr. Grosek, this would be a prime example of possibly using it for that.
Something like this that continues to toil, you know, that could be a circumstance in which the commission elects to go down that path versus how it
Would
normally
we
operates.
send a warning type letter ahead of time that says, you know,
It's
do
a fa- I
this,
mean,
and then the fine would start afterwards, or just give them the
Would the
fine?
building department be in charge of filing charges against them?
no. The commission has the authority under the unsafe building law to fine someone for refusing to comply with its orders. But we gotta have the order first, which takes us kinda to a normal unsafe property. We issue the initial unsafe building order. That person then has time to either comply or to come in and request a hearing. So there is that lapse of time, but in a circumstance like the one that's being referenced, if you have somebody who you don't believe is being compliant, maybe that's the button you push to try to nudge them along.
It makes sense, because we seem to have a lot of people just stringing some along sometimes.
And that circumstance is kind of what I was alluding to earlier with Cagnina and Herrera, right? Prior boards learned from those circumstances, and the same lessons, or similar lessons, can be learned from current circumstances.
What would our steps be in instituting something like this?
Well, the board has taken action to order them to appear at the next meeting.
Mm-hmm.
So I'll have to dig back into the specifics on what we would need to do.
Okay.
And certainly we can have that information prepared at the next meeting, whereas if he doesn't appear, you know, then we can enact an order, or, you know, if something needs to be done, or even have a form order drafted if we need to, that can be taken action on that night.
And we can even still have that discussion on the potential steps if it continues the way it's going.
Yeah.
So maybe, yeah, next month we'll kind of say, okay, maybe we need to start really looking into the finance aspect.
Yeah.
I think it was a great idea.
Yeah. All right, do we have any other public comment for Unsafe? Third call? Seeing none, this meeting is adjourned at 6:40 p.m.